going to go ahead and get started. As some people are probably going to get on just a little bit closer, a little after 11. So good morning, everyone, and welcome to Webinar Wednesday. For those of you who don't know me, I am Shelby, the Membership and Program Coordinator for the Troy Chamber. Before we get started, I do have a few things to go over. You all have been muted just in case there's any background noise because this is being recorded. You will receive a copy of it at the end of the day, probably early tomorrow morning. Next I have, if you have any questions, we're going to kind of do questions throughout. So after each section that Mike goes through, you guys can ask questions either through the chat or by unmuting yourself, whichever you feel comfortable with. What else do I have? That's it. So with that, I'm just going to go ahead and get started. So today we have Mike Scarpelli, who is with Dungan Lefevre. He's going to give us just a quick update on some laws for 2021. If you haven't noticed, over in the chat, there's two forms that he has put in there. Feel free to download those and use them, but they will be up on the screen as well. So I'm going to hand this over to you, Mike.
Well, thank you, Shelby. Thank you, everyone, for attending today's webinar. Like Shelby said, really, it's really just kind of quick updates, employment law, HR-related law, for 2021 and of 2020. So again, it's three main topics that are related in some ways, not necessarily flow together. So as Shelby said, after each section that I go through, I'll try to open up the floor to any questions anyone might have about that topic, other than having you wait until the end, try to remember what questions you might have had about the first section at the end of the seminar. That's the way we're going to do it today. And again, as Shelby said, in the chat, should have two PDFs of the documents I'm going to go through kind of as a guide today. But again, as a help to you, I'm sharing my screen currently. I've got all my visual aids queued up. So just want to make sure you get the information one way or the other. We're as flexible with you as we possibly can. And again, it's just some quick updates. So hopefully I won't take the full hour. But again, I'm always happy to answer any questions you guys might have. As Shelby said, I'm an attorney at Dungan Lefevre, a law firm here in Troy, Ohio. I'm originally from Vandalia, born and raised, still live there with my wife, two sons. Been here at Dungan Lefevre about 2 years, practice mainly business litigation with obviously a focus on employment related matters. So glad to give it my best shot and go through these updates with you, and hopefully it helps you and your business as we go into 2021, which hopefully is a lot better than 2020. Can't get much worse than 2020, to say the least. First topic is the minimum wage. And really, this is kind of a general topic. Each year, you should be looking for updates regarding the Ohio minimum wage. Reason for that, some quick background, is in 2006, voters here in Ohio passed a constitutional amendment to the state constitution that basically said that each year, on January 1st, the minimum wage is going to be automatically adjusted upward to account for inflation. So basically that started January 1st of 2007. Originally it was set at about $6.50. And as you can see, going forward to 2021, it's increased from $8.70 to $8.80 for non-tipped employees. For tipped employees, you're required to pay a minimum wage of at least half of what the standard minimum wage is. So that's why it's gone up from $4.35 to $4.40 an hour for tipped employees. In Ohio, this only applies to larger businesses. So for year 2021, it's businesses with $305,000 in gross receipts. Again, it's not net income, or really just kind of the gross cash that comes into your business each year. It's $305,000. Again, that number is adjusted upward again each year based on the consumer index. So again, that's in 2006, that number was set at $250,000. Again, it's gone up to $305,000 in annual gross receipts from there. Now, if your business is small enough where you don't hit that number, then it defaults to the federal minimum wage, which is still $7.25. That hasn't been updated in really over a decade. It's been set at $7.25. Again, a caveat to that is obviously there's a new administration in the White House. There's been a lot of talk of increasing the federal minimum wage. I mean, I've heard talk of $15 an hour. That still seems to be kind of a focus of the current administration. So again, this is the big caveat to this is that obviously if Congress passes a minimum wage of $15 an hour, it's going to supersede whatever the Ohio state minimum wage happens to be. So be on the lookout for that. And obviously here at the chamber, be sure to, I'm sure to send you out an update if that ever comes to pass. Any questions from anybody about a minimum wage increase? Again, this is kind of a yearly update, or it should be, that at least in Ohio, it's going to increase at least a little bit to account for inflation. So any questions from anybody regarding minimum wage? Okay, looks like none. So moving on to our second topic is the Fair Labor Standards Act and independent contractors. Now, the Fair Labor Standards Act, again, for about 80 years is kind of our federal catch-all, kind of the standard wage and hour law in the United States. And I'm going to use the acronym, the FLSA, because, you know, us lawyers, we're fast talkers, we're smooth talkers, we like to use acronyms for everything. And, you know, most of your members of Congress are lawyers by training, so they like naming things and they like providing acronyms. So when I say FLSA, what I mean is the Fair Labor Standards Act. And basically what the FLSA does, it's set for every employee of a business, it dictates that a business has to basically compensate that employee for all the time that they've spent working for that business. Sets, again, that's where you get the federal minimum wage from. Sets federal overtime laws for employees. So the important factor here, and why independent contractor, that status is important when it comes to FLSA, is that FLSA applies only to a quote unquote employee of a business. And again, if you're a true independent contractor, they're not considered an employee of that business. So again, the FLSA regulations concerning timekeeping, concerning overtime, concerning minimum wage isn't going to apply to that relationship between your business and a true independent contractor. Now, you might just say, listen, I've got a written contract that says independent contractor agreement. That should take care of it, right? But again, for decades, the courts and the Department of Labor said that's not the determinative factor. Now, what you and your supposed independent contractor, what you label the relationship is not determinative. What is the determining factor is what the actual business relationship, the nuts and bolts of that relationship between the business and the employee or supposed independent contractor. So they're going to go beyond labels. They're going to look at what the actual responsibilities and business relationship is between that business and that potential employee. Now, there's, again, starting January 6, 2021, that the Department of Labor announced that they promulgated a new rule that's hopefully going to clarify where the dividing line between an independent contractor and an employee of a business is for the purposes of the federal FLSA. And there's just a few different moving parts to that and a few different components to that that I'm going to go through here real quick. And then I'm going to try to give you some examples that come from the department itself to illustrate kind of how their new rule works in practice. Now, basically, the determining factor between an independent contractor and a employee is whether that worker is in business for him or herself, which again, that's going to fall under the independent contractor label, or if they're economically dependent on that employer for work. And in that case, they're going to fall under the employee designation when it comes to FLSA. And again, the department's highlighted two, what they call core factors that they say usually determine which side of the line you're going to fall under. The first one is nature and degree of control over the work that the employer has. And again, that's general things like, do they set the location, the time, the manner of the work? If that's the case, generally it's going to fall under the employee side of the divide. Or is it something that there's some flexibility for that? The worker kind of dictates a lot of the details of how the work's going to be done, the timing, location. In that instance, then usually it's going to be closer to an independent contractor designation. Other core factor is what they call the worker's opportunity for profit or loss based on initiative or investment. Now, I mean, I had to kind of think about that for a little bit, what they meant, but what they mean is basically, does the worker, can they increase kind of their compensation or their income from this business relationship through their own initiative, through kind of the broad strokes, broader thinking of the work. And it's not just that, you know, obviously if you have an employee paid by the hour, they work more hours and work overtime, if you're paying that, then they can increase their compensation. That's not what they mean. It's more of kind of the 40,000 foot perspective. Can the worker, can they get return on investment outside of just your standard employment relationship? So an employee obviously can be compensated more for working more hours, or if you're on a commission-based compensation system for your employee or a quota system, obviously they can get more work done more efficiently and increase their compensation. But that's not going to make them an independent contractor. But it's basically if there's opportunity for kind of some initiative on the worker's part to increase their own compensation or return on investment and profit, then that's going to fall under the independent contractor side of the line. And again, if those core factors, you get past those, they don't determine the answer. There's also 3 other factors that they consider that might shed some light on what the answer is going to be. One is the amount of skill involved for the work. And what they mean is that, is it something that this worker, they require certifications or training that you as the employer wouldn't be reasonably expected to provide them in a normal employment relationship. Whereas if the work's basically unskilled, or it's something that the employer could provide training for that individual at a low cost basis, then obviously the individual is going to fall into the line of being an employee in that circumstance. Other factor is the permanence of the business relationship between the worker and that particular business. Again, your typical independent contractor, I mean, most of the time it's going to be a specific job or a specific project. It's going to be limited in duration, probably limited in the contract when the work's supposed to be done, when the relationship ends. Whereas, your standard employee relationship, it's, especially in Ohio, it's at will. Basically, as long as you and the employee want to continue that relationship, it's going to continue. So, but basically, if it's an indefinite length of time, usually it's going to be an indicator that the individual you're dealing with is an employee rather than an independent contractor. This last factor is, again, probably requires a little bit of explanation, or and probably the example I'm going to provide will be helpful in illustrating that. But whether the work is part of an integrated unit of production is the phrase that they use. And what they mean by that is, for an independent contractor, can this person's work basically be segregated or separated out of the normal operations of this business? If they're out doing their own thing, they're working on a special project, especially if you have a contract that dictates that special project, then that's a pretty clear case for an independent contractor. Whereas if someone's kind of basically in the standard operation of the, basically in the assembly line of the business, integrated into normal operations of that business, and that person's gonna most likely fall under the side of being considered an employee, at least as far as the Department of Labor is concerned. Now, you've gone through those factors, and again, the department kind of assumed that, they can try to explain it as best they can in the actual regulation, but they decided they were going to provide themselves 6 examples to kind of illustrate what we're talking about here. So again, I'm going to switch to my other handout here. Try to go through these examples, and then I talked with, Shelby and I talked a little bit before this seminar began, that try to break up the monotony a little bit. I thought this could kind of be our audience participation portion of the program. So I'll go through each examples. I haven't provided the answers on this handout. Just want to give you the situation and see if any of you kind of, based on what I've gone through briefly with you as far as what the regulation dictates, if you can decide this individual in each example is an independent contractor, or if they're an actual employee of this business. So we'll give that a shot, see how we do. First example, Individual is the owner and operator of a tractor trailer and performs transportation services for a logistics company. The owner-operator substantially controls the key aspects of the work. However, the logistics company has installed at its own expense a device that limits the maximum speed of the owner-operator's vehicle and monitors the speed through GPS. The company limits the owner-operator's speed in order to comply with federally mandated motor carrier safety regulations and to ensure that she complies with local traffic laws. The company also requires the owner-operator to meet certain contractually agreed upon delivery deadlines, and her contract includes agreed upon incentives for meeting and penalties for missing the deadlines. So if all of you could give that a look, and I mean, if we have a brave volunteer who wants to weigh in on whether or not this this trucker is an independent contractor or an employee of this logistics company. Anybody?
Could I jump back to something from a few minutes ago? I wasn't able to type fast enough. Not so much on the independent contractor versus employee question, but we're talking about employees who are commission-based. I understand we have to make sure their commissions would equal a minimum wage during each week, regardless of their payment structure. Is that correct?
Generally, that's my understanding, and it's the same for if again for other types of businesses. If you have people that are working off of tips, basically you have to ensure that between the tip and the wage that you're paying, it kind of equals out what the minimum wage would be.
But that has to be accumulated on a weekly basis. For example, if I have an employee that one week has no commissions and the following week he earns $50,000 in commissions, I have to pay him the week in which he didn't earn a commission?
I mean, generally the way, I mean, again, and the big caveat here is obviously happy to answer your questions and provide general information. But I mean, again, I wouldn't take every situation is different. So again, if we were talking kind of privately as far as general legal advice, we go into more detail as far and hash that out. But generally speaking, as long as it equals out on an annual basis, that's kind of what the Department of Labor is looking at. That I mean that those are equalizing in that period of time, because obviously it's they don't want to create administrative headaches for you on a weekly basis, because again, it's hard to account for that just running payroll when obviously commission-based compensation, it's not always, it's going to vary from week to week. So again, it's not something again, my general understanding is it's not something you have to do adjust weekly. It's as long as you're keeping the books and it's going to equal out at the end of the year. That's kind of where we're at.
Thank you.
Any other questions about, I guess going back to minimum wage, I know people kind of came in late, maybe I didn't hear that portion of it, but any questions about the handout on the minimum wage increase? Again, like I said, it's, in Ohio, at least it's adjusted each year. And then, like I said, again, in Washington, they're talking about basically doubling the minimum wage through legislation. Whether that comes to pass or not, certainly a possibility. So it's something that obviously in Ohio, it's adjusted incrementally each year. And then again, depending on what happens in Washington, it could be adjusted quite substantially here in the near future. Any other questions about that? Okay, hearing none. Getting back to our truck driver example, anybody have any, want to venture a guess before I give you the answer about whether this person's an independent contractor or an employee of this logistics company?
People are putting employee in the comments.
Okay, I'm sorry, I'm not seeing the, chat. Yeah, so actually, but the Department of Labor says in this situation, this person is still considered an independent contractor. And I think a lot of you, when you said employee, you saw things like they're putting this GPS in her truck to monitor what speed she's going. And There's these agreed upon deadlines and penalties for missing those. So it sounds more like an employee relationship. But what the department said is that that little sentence there where she substantially controls the key aspects of the work. Now, again, that's kind of a catch-all thing, but key aspects of the work for a long-haul truck driver, obviously, it's just the route she's going to be taking, kind of how she gets from point A to point B. Now, what the company is trying to dictate through their contract is, again, we want you to get from point A to point B at a certain deadline. If you don't meet that, then there's going to be some penalties for that. And if you obviously meet that or you exceed that goal, then there's going to be incentives for you to do that. Now, what the department has said is that's kind of pretty standard for a lot of contractual relationships. Again, if you just have a contract between one company to the other, there might be some, again, agreed upon deadlines to perform. There might be some incentives in there. There might even be some, not necessarily penalties, but something like that in the contract. And again, regarding the GPS, again, that's to make sure that she's complying with government mandated regulations and local traffic laws. And again, it's to limit that company's liability potentially in doing that. But even despite that elevated level of control, the department says that's still an example of independent contract relationships. So obviously the FLSA, the minimum wage laws, the wage and hour laws, overtime is not going to apply to this relationship between this truck driver and the logistics company she's performing her services for. Any questions about the department's explanation for that? Okay, so move on to the next example. It's a little different. So in example 2, we have an individual accepts assignments from a company that provides an app-based service linking those who need home repair work with those who perform home repair work. The individual is able to meaningfully increase his earnings by exercising initiative and business acumen and by investing in his own equipment. The company, however, has invested millions of dollars in developing and maintaining the app, marketing itself, maintaining security of information submitted by actual and prospective customers and workers, and monitoring customer satisfaction with the work performed. Now, this is kind of, again, I think it's supposed to be an approximation of, again, your kind of gig-based economy that we have now. Kind of think of Uber or Lyft, Grubhub, DoorDash, those sorts of app-based arrangements. So obviously, it's going to be real important to those types of employers. It's going to be important to the people that associate with those apps. Kind of as I like to say, kind of a side hustle type thing. So obviously, issue is going to become up more and more in the next decade or so. But again, based on the new rule that we've gone through briefly, any guesses as to whether this individual is an employee of this app company or is this guy an independent contractor?
You're getting independent contractor in the chat.
Looks like we've got, a couple votes for independent contractor. And you would be right. Again, it's that factor that hard to define the opportunity for profit and loss, which again, they kind of gave away the answer in the actual example, talking about he has the opportunity to increase his earnings by use of his own initiative, things the company's not providing to him. I mean, if he's getting training or equipment, it's not being provided by the company. The company obviously has to create the infrastructure to make sure this app is successful in the first place, as far as the tech, the marketing, that sort of thing. But this individual here still qualifies as an independent contractor because, again, it's through his own initiative, his own hustle, he's able to meaningfully kind of dictate whether he's making a lot of money doing this or making, the minimum doing this. So again, some good work by everybody. Again, the department agrees with you. This guy is an independent contractor of the app. Example 3. Again, I didn't think this is the greatest example. I think it's kind of an obvious one, but we'll see what people think. Individual worker works full-time, performing home renovation and repair services for a residential construction company. She is also the part owner of a food truck, which she operates on weekends. In performing the construction work, the worker is paid a fixed hourly rate, and the company determines how many and which tasks she performs. Her food truck recently became very popular and has generated substantial profits for her. And again, so the question, again, I know someone's already weighed in, but whether as to her in this home construction company, is she an employee or an independent contractor? Couple votes for employee, it looks like, and I think you're correct. Again, her side business of this food truck has nothing to do with her employment relationship with the home construction company, because you look at it, it's pretty standard employee relationship. She gets paid a fixed hourly rate. The company determines, where and when and how she's performing her duties. That's kind of your classic employee relationship. And I think the reason the department threw that in there is because they have this thing about meaningful opportunity for her profit and loss, which obviously she has it when she's running her own side business, but obviously that has nothing to do with her ability to affect her compensation with the construction company. If she's going to be paid more, then she's going to be working more hours at the discretion of the company, or performing her work more efficiently for them. Obviously her food truck's not going to have any bearing on what she takes home from her construction job. Example 4, we have a housekeeper works for a ski resort every winter. At the end of each winter, he stops working for the ski resort because the resort shuts down. At the beginning of each of the past several winters, the housekeeper returned to his prior position at the ski resort without formally applying or interviewing. And again, under any guesses as to whether this guy is an employee of the resort or an independent contractor? Couple votes for employee. And again, that's the correct answer. Again, this individual, I mean, obviously he's not working what you would call full-time as in all year for the resort, doesn't it? Which is, again, it's based on the nature of the business he's in, at least the resort is in. But again, this is kind of an indefinite duration, this employment relationship. But again, he's coming back each year. He's not having to reapply. He's not entering into new contracts with the resort each season when he performs the services for them. So again, as far as the department's concerned, this is a employee relationship that's covered by the FLSA. Example 5, an editor works part-time for a newspaper. The editor works from home and is responsible for assigning and reviewing many articles published by the newspaper. Sometimes she also writes or rewrites articles. The editor is responsible for determining the layout and order in which all articles appear in the newspaper's print and online editions. She makes assignment and layout decisions in coordination with several full-time editors who make similar decisions with respect to different articles in the same publication and who are employees of the newspaper. Looks like a couple of votes for employee. And again, that's the correct answer. And this is an example of that integrated unit of production, that kind of difficult phrase I talked about at the beginning of this section. What they mean by that is this editor, yeah, she's part-time, she's working from home, but she's in that the general kind of supply chain of this newspaper. She's making day-to-day decisions about layout, assignments as to what writer's going to be writing what. And again, she's working in close collaboration with full-time, which they give away here, employees of the company. So for kind of all that reason, she's an integrated member of this team as far as the newspaper is concerned. So that's why she's considered a employee of this newspaper for the purposes of the FLSA. Our last example, again, is another newspaper example. This one, a journalist writes articles for a newspaper on a freelance basis. Journalist does not have an office and generally works from home. He submits an article to the newspaper once every 2 to 3 weeks, which the newspaper may accept or reject. The journalist sometimes corresponds with the newspaper's editor regarding what to write about or regarding revisions to the articles that he submits, but he does not otherwise communicate or work with any of the newspaper's employees. The The journalist never assigns articles to others, nor does he review or revise articles that others submit. He is not responsible for determining where his article or any other articles appear in the newspaper's print and online editions. So independent contractor or employee. Looks like everyone's going with independent contractor on this one. I think, and again, that's the correct answer. Here, unlike our part-time editor in the previous example, basically it's your classic freelance journalist who basically submits articles kind of not necessarily on a periodic basis, but from here to there. I mean, obviously, he has some editorial conversations with editors about the editing of the articles and things like that. But otherwise, he's not in the standard kind of integrated unit of production, the supply chain of this newspaper. Again, this is one of these where you can kind of separate out his contribution to the paper from kind of your beat writers, your newsroom staff, your editors, people who are making those day-to-day decisions for the newspaper. So again, as far as the department's concerned, this individual is an independent contractor, not covered by the FLSA. So yeah, I think we did a really good job. That first one was a little tricky, but I think otherwise everyone kind of was pretty able to go with the examples and get to the correct answer. At least the answer the Department of Labor thinks is a correct view of the law. So I think it's a good sign that we're all on the right track here. Just to kind of finish up our new FLSA rules regarding independent contractors. Like I said before, these new rules I think are probably geared towards clarifying the line here, because we have a lot of, with the internet and with smartphones, we have a lot of kind of new business models coming to the fore. I mean, like I said before, the gig economy, Uber, DoorDash, kind of flipping the script on your standard employment relationship. So I think it was important for the department to clarify that. And I think, I mean, in the background, there was also some kind of interesting decisions coming out of California regarding their wage and hour law with Uber and those sorts of gig businesses, which considered those people, all those people, to be employees, which obviously had a great economic effect on Uber or whoever else happened to be doing business in California. So I think from a federal level, it was important for the department to clarify that. And again, why is the FLSA important? Because the FLSA, it gives you your minimum wage laws, your overtime laws, your record keeping responsibilities. So obviously, if you're type of business that you're hiring a lot of who you think are independent contractors, if the department comes back and says you misclassified majority of your workforce, that's going to have some adverse consequences on the bottom line, obviously, every time that comes up. So it's kind of important to stay apprised of how the department is administering these laws, because oftentimes the department's the final say on what this language means, as far as if they're going to try to audit the way you're classifying your employees. And in the handout, I have the rule going into effect on March 8th, 2021. But since the time I've written this and we've sent this out, obviously it was a new administration in Washington, and they've delayed most of the pending rules until May of 2021. And this particular rule, again, may go into effect then, but the new administration might have a different view. I might want to tweak it a little bit, but for right now, it's important clarification to, again, that old question of whether a person's an employee or a contractor. And again, just always look to the chamber or obviously your HR department or legal counsel for updates on when this regulation finally goes into effect. Because like I said, it's that initial determination of whether someone's an employee or not, that has kind of wide-ranging consequences regarding the federal labor laws. And just to go back to the Ohio minimum wage, the Ohio state law, an employee covered by the minimum wage, they define the same as the FLSA defines it. So again, this test is important for determining whether or not your particular worker is entitled to the Ohio minimum wage in the first place. So again, there's some interplay there between the state and the federal laws in that question. And again, any questions about any of that? Obviously, we've gone through the examples, but any clarifications anybody needs regarding the new Department of Labor regulation regarding the independent contractor test? Okay, not hearing any, not seeing any, so we'll go on to the next section. Our last section, again, because I know it's still 2021 and we're still talking about COVID, so I think it was only fitting that we ended with a discussion how COVID still is kind of affecting our federal labor laws. If you recall, in last year, kind of when the pandemic really started taking shape, especially here in Ohio around March and April, Congress passed the Families First Coronavirus Response Act, FFCRA. Not to be confused with the CARES Act, which also had some coronavirus relief on some different issues. The FFCRA mostly was concerned with paid leave for pandemic-related reasons. Initially, I think it provided about 2 weeks of paid sick leave for COVID-related reasons, and then there at full pay, and then there was family leave at a reduced rate, again, for COVID-related reasons. Usually it was to care for a loved one who was sick with the virus, or if someone's children, their daycare, their school was closed due to COVID, there was some paid leave for that. That was set to expire, and it did expire at the end of 2020. But again, as part of beginning of this year, 2021, Congress inserted kind of a provision, I believe it was in some budget legislation, that basically it extended on a limited basis kind of the applicability of the paid leave provision in the act. And by that, I mean, it isn't mandated family leave related to COVID. Basically, it gives your business the option on a voluntary basis to provide family leave to an employee for COVID-related reasons. And again, part of the original act was as kind of a benefit of, again, the government requiring you to provide that paid leave. They allowed you to claim a payroll tax credit for the amount that you were required to pay to the employee. And so what they've done is if you voluntarily provide that leave, now through March 31st of this year is when the new provision expires, you can still claim that tax credit, payroll tax credit for any amount of paid leave your company voluntarily provides. Now, the caveats to that, again, you have to be covered by the FFCRA to begin with, your particular business. And again, that was if your business is over 500 people, then you wouldn't be employees, I should say. You wouldn't be covered by the FFCRA to begin with. That was kind of one of the more controversial provisions of the original legislation. And also, obviously, the employee has to have not expended any amount of paid leave they have under the original act during the original lockdown or pandemic. Those are kind of the broad strokes of that, the caveats to that. And again, in order to claim the tax credit, you have to abide, again, by the record-keeping regulations that are contained in the original act, which, again, about a year ago, the chamber provided kind of an information sheet regarding what was in the original act, who was covered by it, kind of what the provisions were. So obviously I won't go through that and bore you with that right now, but again, there's some information available through the chamber and through elsewhere to kind of let you know if your company's covered by the act and able to claim that tax credit. Again, it's all contingent on a voluntary basis. If you're providing that paid leave, if you want to provide that as a benefit to your employees if they're in that situation, then the government wants to try to reward you a little bit by letting you claim that payroll tax credit. Again, every situation is a little different, so my general advice would be if you have specific questions, obviously, I'm glad to discuss that privately. And I'm sorry, I'm just looking at a chat question from Kelly. Where can we find the record keeping info? I think we would qualify as we had some employees who had to quarantine due to COVID. Again, Kelly, I think it should, and Shelby, maybe you can answer this for me. I think if that is that info sheet that, again, I provided that one, it was back in March or April. I don't know if that's still up there on the chamber website.
Yeah, what I'll do is I will put that in the email after this. I do believe I still have it, so I will send that out with the recording of this too. So.
Okay. And yeah, and Kelly, if that doesn't provide the answers, then I'm glad to, I can, if you want to try to email me or email Shelby and she'll pass it on to me and I can try to give you some links to, again, the feds are pretty good about laying out kind of what the requirements are, so you don't have to read the 200 pages of the actual regulation. But obviously glad to help out just after we adjourn here if you have any follow-up questions. But hopefully, again, in the info sheet, it's about a couple pages. It kind of has some bullet points about the applicability of the act and which business is covered and able to claim the tax credit. And yeah, you're welcome, Kelly. Thank you. Any other questions about, again, it's basically providing FMLA leave, because again, the FFCRA kind of defers to FMLA as far as what's covered for family leave. It's just a matter of whether it's going to be paid or not. Any questions about, I guess, this kind of brief extension of the paid leave provisions to people who are providing it on a voluntary basis? Okay, not hearing any, not seeing any in the chat. Again, I know I had some people we kind of trickled in a little late after I started, but any follow-up questions on any of the things we went over today? Minimum wage increase. Again, we had a lot of discussion about the independent contractor issue. I mean, I hope you found that helpful to some extent. But any questions about that? Anything you found confusing? Anything else we can do for you today before we let you go?